I'm Julie Kong. I'm a solicitor here at Heptonstalls. I'm in the private client department and I specialise in wills, lasting powers of attorney, court of protection work and trusts. Okay, this is a really common question that I get asked by a lot of clients when they come in to see me. Unfortunately, people often don't think about the problems faced with dealing with their loved ones' finances or assets, because until they need to become involved, they're not, and often that person is able to contact the bank, internet banking, etc., and do what they need to do. Unfortunately, dementia and mental illness, etc., is becoming more prevalent in today's society, and I'm having an influx of people that are sadly in a position where they haven't applied or entered into a lasting power of attorney when they're able to do so because their mental capacity allows that. And it's now necessary to look at the options available to take over their mother or their father's finances. And so in such circumstances, it's important to establish whether somebody has the required mental capacity to deal with their money. If they do not, and a capacity assessment has been undertaken by a professional, then it's necessary to make an application to the Court of Protection to enable you to have that power to act on your mother or father's behalf. And the order that you would receive from the Court of Protection explains what powers you do have. They can be limited or they can be quite far-reaching. It very much depends on what powers you are seeking, and that's important that it's included in an application that's made to the court. Once you have an order that explains that you're able to deal with your mother or father's assets, you are able then to take it to the bank, and the bank will take copies of that alongside your own identification, and you're able to access your family's funds. It's not as straightforward as a lasting power of attorney, and I do always say it's preferable, if you're able to do so, to go down that route. The reason for that is because the Court of Protection application is very much governed by the administrative arm, which is the Office of the Public Guardian, and a deputy, which is the official term for somebody who has been appointed to look after your loved one's assets, has to report annually to the Court of Protection on how they're spending your money to make certain that they are protecting the loved ones, the vulnerable person's finances. The difference between a lasting power of attorney and a deputyship is that a lasting power of attorney is made when the donor, i.e. the person that wants to give those powers to their attorney, their friend, their family, whoever, has the capacity to be able to enter into it. They know exactly what they are doing and they're able to give that power to somebody else. The contrast for a deputyship is that that person sadly no longer has the required capacity to give that power or that authority to that other person, because they no longer have the required capacity to make certain decisions on their behalf. And capacity is defined by the Mental Capacity Act 2005, and it's quite far-reaching in that it depends whether you can understand the value of your estate, retain such information, whether you have a brain-sustained injury or a mental health condition, etc., to the required limit that means that you're unable to act on your own behalf anymore, and you need that assistance from a third party. And so the difference in the two tools, if you like, as and when they're used, is that a lasting power of attorney, when you make that and you know that you're making it, you're able to restrict it, so you can say that certain people can't deal with certain policies that they may have, or certain bank accounts, or any number of restrictions, preferences or instructions you can include in that document, or it can have no restrictions whatsoever. And so your attorney is able to deal with all of your affairs and also your health aspects as well. If it's a lasting power of attorney for health and welfare, there are two. But in terms of your finances, if there are no restrictions, then they can deal with all of your property. They can sell your home, they can go to the bank on your behalf, and they don't need to seek authority from anybody else to do it, because the authority comes from that document. Once it's been registered by the Office of the Public Guardian, it's valid. Alternatively, with a deputyship application, there is an order that sets out restrictions that your deputy is only allowed to deal with certain aspects of your estate. So that may allow your deputy to go to the bank and deal with your affairs as if they are you. And they need to report back as to how they have accessed your funds and used your money, and that has to be reported annually, so they need to keep a good record of how they've been dealing with your affairs. If they need to sell your property, for example, or they need to purchase a property on your behalf using your funds, then they need to, in some cases, apply to the court once more, even though they've been appointed as a deputy, for that extended power to be able to do that. So the Court of Protection orders are often limited to allow your deputy to only do certain things that the order permits them to do. So a deputy can be any number of people. Often people choose to appoint themselves or apply to the Court of Protection to be a person's deputy when they're a close family friend or a family member, and as long as they're suitable for the task, then the court will be able to appoint them on the protected person's behalf. Alternatively, there may be reasons why there is nobody available in the family or friends that are able to be that person. And so the other option is that a solicitor is able to make that application and be appointed as a professional deputy on that person's behalf. And often that can be because, like I've said, there is nobody suitable, or alternatively, the funds are extensive, the person's estate is rather large and it needs to be dealt with professionally. To apply to the Court of Protection, I always suggest that people take professional legal guidance when they're making such an application, because it's quite a large responsibility. And I think it's important that the person that's making that application fully understands the implications of what they're seeking. You are able to make such an application yourself, but I always suggest that you seek the advice of a solicitor who is able to assist you in filling out the forms for such an application, because the forms are quite lengthy and there are many of them. It isn't one form fits all, unfortunately. So it very much depends on what power you are asking the court to enable you to make decisions on behalf of your friend or your relative. And that subjects to what form you actually complete. And so a solicitor is able to guide you in the right way and fill the forms in on your behalf. You will also need a capacity assessment that will need to be undertaken of the person that you are seeking to apply for by a health professional, somebody who's involved in their day-to-day health treatment team, a consultant, their GP, etc. And so that application is sent to the Court of Protection alongside the capacity assessment, and the court then consider whether or not you are deemed to be the most suitable person to be that person's deputy. But solicitors' involvement shouldn't stop there in just making the court application. We're able to guide you as to how to deal with the person's assets, your responsibilities and your roles and your duties to the Court of Protection and the Office of the Public Guardian, particularly in your annual reports. How to do those, we're able to assist you in what is required and what evidence you need to support to the cause. Also, once an order has been made, there may be circumstances where you need to vary the order that you have already got. For example, if the person that you are appointed as a deputy for owns a property jointly with another person, and the other person now, the joint owner, needs to sell this property. Unfortunately, because the other co-owner has not got the required capacity to be able to deal with such a sale, it might be that a separate order needs to be sought to enable the deputy to appoint a second trustee to deal with the sale of that property. And so the Court of Protection, it deals with so many varied applications and powers to assist a protected person when they're not able to make decisions for themselves.